Miranda myths. What actually matters.
When people hear the term Miranda rights, they often think of what they've seen in movies and TV shows. Officers arresting someone and saying, "You have the right to remain silent." But there are a lot of misconceptions about what Miranda warnings actually mean and when they apply. Let's clear up 3 of the biggest misunderstandings. First, many people believe that if the police don't read them their Miranda rights, their case will automatically be dismissed. That is simply not true. A Miranda violation usually results in the suppression of any statements made during a custodial interrogation, not a complete dismissal of the charges. This means that if the police question you in custody without informing you of your rights, your statements may be excluded from evidence. However, if there is other incriminating evidence against you, such as physical evidence, witness testimony, or surveillance footage, the prosecution can still move forward with your case. In short, failing to Mirandize a suspect doesn't mean a case is thrown out. It just limits the evidence that can be used. Second, you will not always be read your Miranda rights. The police only have to inform you of your rights if they are conducting a custodial interrogation. That means you have to be both in custody and being questioned for Miranda to apply. If officers already have enough evidence against you and don't need to ask questions, they may never read you your rights. For example, in DUI cases, police often gather evidence through field sobriety tests, breathalyzers, and observations of impairment before making an arrest. Because they don't need a confession, they may never Mirandize you at all. The same applies in many other types of arrests where officers rely on other forms of evidence instead of direct questioning. The third misconception is that remaining silent can be used against you. The reality is that you have a constitutional right against self-incrimination, and exercising that right cannot legally be used as evidence of guilt. Some people think that by staying silent they look guilty, so they try to explain themselves to the police. But talking to officers without legal guidance can do more harm than good. Many people inadvertently say things that are later twisted or used against them in court. That's why it's so important to say nothing and wait to speak to an attorney. If you have something to say, make sure it's through legal counsel so your words are not misinterpreted or taken out of context. Understanding your rights is critical if you've been accused of a crime. Before answering any questions, you should always know what is legally required of you and what is not. Our office has successfully represented clients in both pre-charging and post-charging situations, helping them make strategic decisions and safeguarding their constitutional rights. If you are facing criminal charges, don't navigate the legal system alone. Contact us today to schedule a consultation and get the legal guidance you need.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.